All right, let's go ahead and just move right along there. We're going to bring John Kingston on in right now to talk a little bit about the continued topics of broker carrier liability and if this case is actually going to head up to the Supreme Court. John, thank you for being here. I feel like we've covered this topic from almost all sides now, besides from the judicial side itself. We've talked to Ann Reinke from TIA about this. We've talked to Matt Loeffler about it from a legal perspective. Yeah. Now let's hear from you on your thoughts about this broker carrier liability and if it gets shot all the way up to the top court next year.
Well, let's just catch everybody up on what happened. So there have been several decisions, even at the appeals level, regarding whether a broker is liable if it books company X, carrier X, and something terrible happens. And in two of the cases that are at question, it involved an injury or a death. And there's a case out there also involving a carrier, a truck that was stolen. So most of the decisions on the appellate level have come down in favor of the broker not being liable for this, under the idea that the Federal Aviation Administration Authorization Act, the so-called F4A, preempts this from happening. However, there is another case out there, Miller versus Robinson, in the Ninth Circuit, which found that the broker, in this case C.H. Robinson, was in fact liable for, I think it was not a death, but an injury that happened to Mr. Miller. So Miller versus Robinson went up to the Supreme Court for review, or a request for a review, and it was denied. It was denied in the same week that AB 5 also was denied. Well, since that time, you've had these two significant cases. You've had the Landstar case, which involved a truck that Landstar broker that was stolen, and you had the Yee case, a case where Global Trans booked a truck, and that truck killed somebody on a motorcycle. Those two cases found that the broker was not liable. Miller found that the broker was liable. All these happened on the circuit, on the full circuit decision, or not the full circuit, but the appellate decision. So you've got a conflict here. So the fact that my recollection is that Miller versus Robinson did not have an obvious conflict. And now you have very much an obvious conflict. You've got Miller on one side and these other two cases on the other. There's also a lower court decision out there handed down fairly recently that kept Coyote Logistics from being held liable for an accident. So the widow of Mr. Yee, actually I guess her name is Yee, has requested that the Supreme Court review it, and now we'll just have to wait and see. It may take till the end of June to find out whether the Supreme Court will actually take this up. But you do have the kind of fertile ground for this, in that you have conflicting appellate decisions.
Yeah, since we're going to have Matt Loeffler on this again later on in the week a little bit. John, and I don't know if this is the right question necessarily asked, but in terms of this from an overall perspective, you've got these different cases that were obviously argued and won or lost different ways. If this does get shot up to the Supreme Court, what's the question that they're going to be asking? Is a broker a motor carrier? Are the two separate? Or is F4A applicable in these situations? What do you think, if this goes to the Supreme Court, what's the question they're going to be asked to rule on?
Yeah, well, you hit it on the head. And the question is, within the F4A, there is something called the safety exemption. And the exemption basically is that a carrier or any kind of a motor vehicle, whether it's a motor carrier or motor vehicle, cannot be completely and totally reckless and then claim exemption or protection under F4A. The question then becomes, is a broker a motor carrier? And in the case of Yee, the lower court decision that was upheld by the appellate court, is that since Global Trans is not a motor carrier, they only booked a motor carrier, the safety exemption can't be invoked to kind of bring them in. That was not the finding in Miller. So just as you said, that will be the case. Can you find that a broker is a motor carrier and therefore the safety exemption can apply to them? You can't just act in a reckless manner because you're a carrier, even though obviously, C.H. Robinson doesn't own trucks. It wasn't their trucks that was in the accident. So yes, that is going to be the key question if it does get to the Supreme Court.
So, John, on that, maybe even getting a little bit more nuanced into that question as well. Obviously, you have brokers in this industry who are asset-based brokerages. You have brokers in this industry who are asset-light. And at the end of the day, you could be both a brokerage that has its own assets, but still chooses to broker freight out to other carriers if your own assets are tied up in the specific space. Do you think that we maybe even get more nuanced where you have to then divide up, okay, you maybe are a brokerage that has its own assets, but you operate your brokerage independently from your motor carrier and separate that out, or do you think that that's going to be too nuanced?
I don't know, but as you point out, any kind of sort of standard truckload carrier has a brokerage division. If the brokerage division puts freight into Company X and Company X goes out and drives in a reckless manner, or maybe just, whether it's reckless or not, ends up in a fatal accident, does the safety exemption take into account the fact that they had an asset-heavy division with tractors and with trailers, et cetera, or even though it wasn't that asset division that was involved in the accident? So I'm sure that would be one of the questions. Does the fact that if a brokerage has assets, does the safety exemption not count with them, even if the accident did not take place with one of their trucks? It took place with a truck that was brokered into by their brokerage division.
John, are there any areas where this could perhaps not have an effect? In other words, obviously we're talking about an accident involving a truck, but the Supreme Court rarely makes rules that are just completely broadly across the phase of an entire industry at some point. Are there areas of this that may not be affected no matter what way the Supreme Court does, or even if they agree to hear it?
Well, I'm not really sure the question, but right now, the way it stands is that the Ninth Circuit is the place where the Miller versus Robinson rule handed down. So that ruling, which basically finds that the broker is not protected by the safety exemption, that would be in effect in the Ninth Circuit. The other two ones, the Landstar case and the Yee case, involving Global Trans, would prevail in the circuits that they're involved in. I think it's the 7th and the 11th. What it also means is that all the other circuits that don't have a precedence here can pull on any of the writings that are out there. So they may turn to the Ninth Circuit, which is obviously very bad for brokers, or they could turn to the other circuits, which is much better for brokers. This is why you might need the Supreme Court to clear this all up, so you get kind of a uniform ruling on what the F4A does protect and what it does not.
And so, John, of course, then the question is, ripple effects downward in the industry, specifically in the brokerage space. Do we see this maybe in increased insurance rates or increased insurance amounts that brokerages are going to have to hold now if it comes down on the favor of not the brokerages? Or do we end up seeing it, if it does come down in the favor of the brokerages, where they say, we kind of got off scot-free and we don't need to change our operations?
Well, I don't set insurance prices, so I'm not sure of all the calculations and data that goes into them. But I would think that any kind of level of protection would be a plus for insurance rates, a plus in the sense of protecting brokers from higher insurance rates. So it wouldn't have any impact. I can't imagine why it would have any impact on carriers. This does not affect carriers.
So, John, just to wrap things up, I mean, obviously, if you have a disagreement between these district courts, then you would hope then that the Supreme Court would indeed take it. What's your odds on that they will take it next year?
The odds are low because the Supreme Court gets many, many requests and rejects the vast majority of them. It's a small percentage. So the odds are that they won't take it. But, boy, this does seem like one that they should. I mean, this is very clearly this is not a minor thing. I mean, this is a federal rule, the F4A, that's been in effect for 30 plus years, that has a lot of impact on a lot of areas of transportation. As we know, it was the argument that led to the AB5 injunction that was in place for 2.5 years, and which is still before the court. So I mean, I would think that that's clarifying what F4A does and what it does not do is an important issue. Of course, all those other lawsuits that are asking for review, they'll tell you that they're also really important too. So we'll see how it plans. I hope they review it because I want to go down and listen to the oral arguments. I think that would be exciting.
I think it would be exciting as well. John, thank you for joining us this morning. And of course, we will keep up with you as this develops.
Thank you.